Good evening, this is Laws 11057, Introduction to Law. It's week 6. We're dealing with communication, collaboration and self-management skills, and tonight our discussion is based around chapters 9 and 10 of The New Lawyer. Tonight is intended to be quite a practical session. The reason for that is that it's all very well to know the law, but it is important to practice the law in a proper way. Now, what do I mean by that? If, for example, you miss tomorrow morning's court appearance before a judge or a magistrate, and you then roll up an hour late, the matter may have already been determined. So it's not going to be a terrific response for your client or the court to simply say, "I'm sorry I'm late, I forgot, but I did prepare a lot of good work for this." Right at the start, you're way behind the 8 ball. So being able to communicate, collaborate, and to be involved in self-management in a way that works is really important. And this is all examinable. Last week, I mentioned that I'd like you to start doing some work on giving some tips in relation to the Australian Guide to Legal Citation. So if you do have any tips, please add those onto the website. And that's the style that's used in this university. It's used very widely in law circles generally, so it's common around Australia, if you like. So there are some very good text materials available to you. Can I say that in terms of feedback for the first assessment, I was really generally very happy with the work that you've been doing. I think the way in which you've referenced your material overall is excellent. I did like the pinpoint referencing that people were using. People were using italics appropriately for legislation and the name of the case. And that's all great. It's really important, I think, that you get that right so that you're going to be writing with some authority. People will take you seriously. So I appreciate the efforts that people are making in that regard. But I do ask that you please keep a very close eye on written materials, because those written materials will give you a good guide into the future as to how to learn. So as I may have mentioned before, it's almost like an osmosis thing. You see it enough and you'll pick up on it, but I do want you to be observant. Now I'm going to ask you to turn to page 307 of your text. And in particular, I would like you to just have a look at the top of the page, and I think this is an excellent way to begin a paragraph. Just a reminder, if you've joined us, just turn off your microphone by hitting the mute button. Of course, unmute it if you wish to come in and ask a question, but otherwise we'll just get you to mute. So on page 307, lawyers are essentially wordsmiths, full stop. They are experts at working with words in both written and spoken form, full stop. For this reason, then we go on. As you probably know, that's the sort of thing that I like to see. Writing in simple, short sentences is often a very effective way to do things. You've probably also picked up on the fact that I'm not terribly keen on lists. That's not to say you can't use them. Of course you can. Or you can use enumerated paragraphs if you wish as well. But just have a look at the list below that paragraph that I've referred to. And if you're like me, you tend to gloss over that a bit. And the readers can switch off. So that's one of the reasons why sometimes I think lists aren't necessarily a good idea. So of course, when we're talking about communication, we're talking about being able to communicate what is important and do so effectively. We'll be talking about client communication shortly, and of course in that sense it's a two-way street. But generally speaking, unless there's some particularly good reason to do so, you will try to communicate in a simple manner. Have a look at the think box on page 307 down the bottom, and you'll get a good idea of what I'm after. And the authors make the point about, what do you think of lawyers communicating? What are the first images that come to mind? Now, some people might say lawyers, pompous, use jargonistic language, perhaps arrogant, use archaic language, the whole range of things that you might think. I suspect that you probably wouldn't think about lawyers as being people that communicate using short sentences and easy to understand phrases and questions. But that's the way the law is moving, and that's the way I'd encourage you to communicate in both your written and verbal form if possible. But do you remember that option that I gave you in week 1? Where I think I gave an option about what it's like to be a law student or communicating. And the second option, after a long rambling first option, second option was something like communicate effectively and simply. So don't be long and rambling, just get straight to the point if you can. Okay, so let's talk about interviewing clients. This is all examinable. And the purpose of the exercise is to have you start thinking about your technique when speaking with clients. I'm going to invite you to make some comments now. Use the chat facility or come in online. But just a few words if you would. What do you think are the most important things that you should be considering when it comes to communicating with clients? All right, so just come in on the chat facility or join me live if you wish, and I'll monitor what's happening. Listening. I like those words. Clearly and simply, yes. Make the client feel active listening. You're doing very well. Building trust. Make the client feel comfortable and trust in you. Active listening. Facts. That's all good points. Okay, so I'll move on. What we understand their point of view. Thank you. So I think what you need to do is understand that it's important that you ask the question, essentially, what do you want? And an equally important question, what do you want me to do? If we could ask those two questions and have them answered, we're doing very well, I think, in terms of our communication with the client. What do you want and what do you want me to do? Sometimes I ask those specific questions if I feel that the client is rambling or getting off point or not focusing clearly. You do need to listen very carefully, and there's a difference between passive listening and active listening, and you need to be an active listener. If you're an active listener, that means that you are being proactive, you're being light on your feet, you're thinking of alternatives, you're being able to generate ideas as you speak. Another thing that is important is don't jump in too early. Sometimes you need to let the client speak a bit and have an opportunity to say what the client believes needs to be said. You can't let that go on too long. What we don't want is a situation where you have put on your timesheet that you spend an hour with the client. The client may not want to pay for an hour of your time, and you may respond by saying, well, the reason I took an hour is that you just talked the whole time. You didn't give me a chance to say anything or give advice. So sometimes you need to be authoritative and you need to take control. So let's talk about some of the techniques in terms of face-to-face interviewing with clients. You need to be comfortable in your demeanour. You need to make sure that the client is comfortable. You need to be authoritative, of course. Maintaining eye contact is always an important thing, and being attentive. You know, your body language is important. If you're sitting up looking to obtain information from the client and presenting in a warm manner, then the client is likely to respond to that. Just as an exercise, why don't you tonight, just in speaking with someone, adopt a couple of different ways of body language. The first alternative might be that you sit back, appear to be disinterested, you don't maintain eye contact, you don't seem to be paying attention. See what sort of response you get. And then during the course of that conversation, just change and sit up, become more attentive, maintain eye contact, look interested, become more proactive in perhaps in your verbal signals, and just see what response you get from the other person. And I suspect that they will follow your lead and they'll become more attentive as well. Anyway, just a little exercise that I'd like you to consider doing. So you need to be respectful, of course. You need to clarify certain points from time to time. So what do I mean by clarifying points from time to time? There's a couple of techniques that we use in alternative dispute resolution regularly, and that's another subject that I take here. One is what we call reframing, and the other is summarizing. Now, there are many more, but these are two examples. Now, by reframing, what I'm suggesting that you might do is essentially describe back to the client what it is that the client has said, but in doing so, you detoxify the statement. So it might be something like an employment dispute, and I'm thinking off the top of my head here, where the client employee says, those people over there, they've never treated me with respect and they're always doing this and they're harassing me all the time. Just try and detoxify it by saying, all right, so you believe you haven't been treated fairly. So you're trying to bring it back to the facts, detoxify. You know the client's angry, but you're not going to put in a material you're not going to put toxic material in your affidavits. You're going to try and stick to the facts in that regard. So you need to detoxify. Reframing is one way to do that. Another way is summarizing, and that, as the name implies, taking the concepts and using it in a more efficient way than perhaps the client had done from the outset. One technique that I do use in hearings, in guardianship, in QCAT, is I'll use voice recognition software, and during the course of the hearing, I might reframe what has been said or summarized what's been said, and just have that recorded on my laptop as I progress. What that means is that at the end of the hearing, I might have a very clear, summarized idea of what has been said. So using voice recognition software is one way to maintain eye contact but still record accurately what has been said during the interview. Which brings me to the next point, and that is you need to take notes, but you need to do so carefully and perhaps selectively. If you're going to be taking the notes in circumstances where your eyes are diverted from the client too much, the client may take your note-taking as being a negative body language. So you need to be careful about that. If you are going to take notes, try to perfect the art of writing a few words carefully so that it's accurate, that it's at least comprehensive to a point, and but still you're able to interact with the client. Ensure that you appropriately respond to certain questions. As I said, the important questions are, what do you want and what do you want me to do? Make sure, of course, that the client is aware of your responsibility to maintain confidentiality. You perhaps don't have to say that, but it's probably a good idea to consider saying that so that the client is more comfortable in speaking with you. I think afterwards it's always important to confirm the instructions in writing and at least have some evidence of the interview. So if you weren't able to take appropriate notes during the interview, then you might like to make some notes after the interview, immediately after the interview if possible, and better still, confirm any instructions in writing. Now, a few other things that you might want to consider: empathy with the client to a point, but remember it's not your dispute. It's the client's dispute. It's the client's matter. You take an interest, but you don't take ownership necessarily. Clients want to be able to maintain control of their dispute. Remember, you're there to advise, provide options, sure, but ultimately it's not you to make the decisions about the conduct of a matter. So question appropriately. Remember, of course, that interviewing clients can be regarded as a good way of practicing your advocacy techniques, because you are asking questions, a bit like cross-examination. You're asking questions to elicit information, and you're trying to, at the same time, think on your feet and take notes. So there's a bit of an art to it. So one way you can do that is keep questions short, avoid double negatives. That's a real no-no. And I'll mention this a fair bit, but use the active voice rather than the passive voice. And I'll talk about that more in written communications. So there are some things that you might want to consider doing in terms of those techniques. All right, are there any other points about client interviews face-to-face that I have overlooked? Does anyone wish to make a point? Someone says, Millie says, is it valuable for a lawyer to adopt shorthand? I think there's a lot to be said for that. I'm not sure many lawyers know much about shorthand, but it's probably a good idea. Understanding their point of view, says Kathleen, gain trust, converse coherently at their level. I like that point, at their level. That's an excellent point, thank you. Make sure the client understands. Ask open questions. That's a very good point. I like that. Thank you, Rebecca. Talk through the range of possible and realistic options for the client. Thank you, Diane. So these are all really good points. And I want you to think about that and have a game plan ready, not just for the exam. There may be a question on the exam, I'm not sure, but just generally for your practice as well. Okay. Think about your client's interests and not necessarily your client's position. Your client's position might be, I want to sue these people, they've done me wrong, and I don't care how much it costs. And I don't care how long this is going to take, but I want to sue them for everything they've got. That might be their position. Their interest might be to resolve this as quickly and as efficiently as possible, and in so doing, maintain better emotional stability and maintain a better bank balance and maintain better relationships with people that they care about. Clients may need to be reminded of that. I don't mean to take the dispute away from the clients. I've already made that point, but sometimes clients need a firm bit of guidance in terms of focusing on their interest and not just their position. I hope you can understand that subtle distinction between the two. All right, so let's talk about courtroom advocacy. Courtroom advocacy, be prepared. That's number one point. When I say be prepared, what do I mean by that? Well, it's not just a matter of being prepared actually in the courtroom. There's a lot more to it than that. It means being prepared before you actually go to court. It means being prepared the day before. It's always good to have habits, good habits. In my situation, because I'm in court practically every day, what I have developed is a habit of, in a particular spot in my room, there will be the files for the next day, so that they're ready to proceed. And if I'm going to court the next day, I am confident then that I have everything that I need. And if I don't have something which needs to be put there later, I might put a post-it note or something. So some sort of physical way of being prepared. Being prepared might be providing some written material. Be concise if you do so. If it's a submission to the court, have that prepared. And that might be a good way to deal with advocacy nerves as well, having something that you're actually going to submit to the court for the court to read rather than you necessarily being on your feet to say it all. You know, one thing that I do like, and this comes back to that CIRAC method, is if you're on your feet in an advocacy situation, why not state your conclusion from the outset and then work towards that? In that way, the court will know immediately what you're trying to achieve, and the court might be grateful for that, to say, all right, so your submission is that this should occur. All right, let's see, tell me about that. Why do you think that should be the appropriate case? And it's a good way of having the court with you. Alternatively, if the court is against you, you'll know very quickly that the court is not going to consider that. I mean, I guess from time to time you have a situation where from the outset you state your ultimate conclusion, the court says no way in the world, but then 20 minutes later the court does come around to your way of thinking. When that does occur, that does make you look pretty good for the client. So keep that in mind as well. But if you're not going to get what you're after, then perhaps it's a good idea to at least ascertain that from the start and maybe warn your client that that's what you intend to do. and just suggest to your client that the reason you're doing it is to get a better idea of how the court is thinking from the outset, and that you've got a plan to deal with that. Okay, so take your instructions in a form, or like this. So quick grab, give in the conclusion first, will command their attention and keep them interested. I like that thought, thank you. Take your instructions in a form that you can rely upon under pressure. So can someone tell me, what do I mean by that? How can you take your instructions in a form that you can rely upon under pressure? Any thoughts? You can come in live, you can talk if you wish, or you can just pop it on the thing. How do you take your instructions in a form, something you can quickly refer back to for your train of thought? I like that. So it's a quick guide. So if you get lost, or if the court asks you questions which are off topic, you can bring your way back into it. Okay, what I have developed, I suppose over time, is some pro formas that I use. They make sense to me. And it might be something that you think about. So the one advantage of a pro forma, of course, is that things are in the same spot irrespective of what matter it is. So if you have a pro forma, you might say, well, anything to do with the background of the client's age, antecedents, education, health, that's all in one spot on this prescribed form. So I make those things up for myself, but there are plenty around there. So maybe using a prescribed form is a good way of doing it. Another way is to perhaps use highlighting, use dot points if you wish, things of that nature. One of the things, of course, with advocacy is make sure your research is done well in advance. Perhaps have your law available in some sort of written form. Many courts will allow you to use iPads or laptops. There's no problem with that generally, but sometimes it's good to have it in print. And importantly, in advocacy, you may get some valuable brownie points if you make necessary concessions or consider the alternative argument. And that way the court will be more likely to accept what you're saying because you've been eminently reasonable in relation to certain things. Oh, I didn't say what we should have said at the start, and that is when you do appear in advocacy, you need to announce your appearance. So, for example, I might say that in relation to the matter of Smith, my name is Milburn, initials J.A., lawyer with Milburn's Law, and then go on from there. So that's what we mean by an appearance. So you'll need to practice that, announcing your appearance. If you haven't been into a courtroom to have a look, I'd urge you to do so. In Hervey Bay, people regularly will spend an hour or half a day with me, just following what I'm doing, and I don't mind that. And there might be other practitioners in the area where you are that would be happy to have you come along. Or even if you just sit in the courtroom and just watch. I think that's really important to get an idea of what's happening. Make some notes. So after you've announced your appearance, what you need to do, well, you need to be confident. Don't rush. Speak clearly. Speak just a little slower without being too slow than you perhaps might be in a conversational situation, because you are in a formal setting and it just takes a moment for the words to project across a room. There are some specific issues that may come up from time to time. So let's say application to set aside a judgment. So this is a civil matter. You're acting in an advocacy role for a client who has suffered a judgment against, let's say, him. And the reason that he suffered the judgment is he forgot to come in and see you so that you had a chance to file a defence. But he does have a good defence. So in that situation, you might be on your feet arguing before a magistrate or a judge that the judgment which was entered by default by the registry office should be set aside, that is cancelled, because your client had an arguable defence, because there were good reasons for the delay, because the other side didn't suffer any prejudice, and as a compromise, to be reasonable, you might make an offer to pay the costs that the other party incurred, which would be thrown away, is the term we used, as a result of you getting the order you want, which is to set aside the judgment. So plan for those sorts of things. In the criminal law jurisdiction, you might want to do a bail application. And a few things you need to determine. The first is this a show cause situation or not? In other words, who has the onus here? Who's got to overcome the burden, as it were, in the bail application? So if someone is charged with a very simple matter of trespass and prosecution wish to object, then the general rule is that bail will be granted unless there's good reason for it not to be granted. But if someone is charged with murder, then the opposite would apply, or if they've been charged with a matter which involves a weapon. So we call that a show cause situation. Anyway, what are the sorts of things that you might do to prepare for a bail application in criminal law? You want your client to be released from the watch house pending the trial of the matter. How would you prepare for it? Well, you might ensure that, if possible, you have some references or maybe letters or certificates. Maybe you consider the criminal history. Maybe you should consider the objection to bail and prepare some arguments based around those things. But proactively give good reason why he or she should be bailed, family will suffer, etc. That's very good. Applicable laws and bail conditions, thanks Rowan. Flight risk, try and address that. Job offer, yes, that's another good one. There's a job to go to. A place to stay. Maybe you should speak to your client about offering get an introductory statement or position from the client, yes. Maybe you should speak to your client about offering to the court some conditions. Your client might say, well, I'm prepared to go into the watch house, I'm prepared to go to the police station and sign in twice a week. Or I'm prepared to have a condition that I don't consume any alcohol until this matter's resolved. So that way, on your feet, you can offer some way for the court to grant your client bail, even if it means suffering some conditions. Okay, and just finally, in terms of advocacy, I want to talk about the process of cross-examination. Cross-examination, of course, is where we have a situation where we are asking a witness to provide responses to a particular question. Here's the thing you need to avoid, and that is the witness being able to answer your long question with yes or no. That's really got to be avoided. So in cross-examination, generally speaking, try to keep your questions quite short. As always, avoid double negatives. No double-barreled questions. What do I mean by double-barreled questions? On the night in question, you were driving a red car. That's double-barreled. First question, on the night in question, were you driving? If the answer is yes. Second question, were you driving a red car? Do you see what I mean by that? So the first is double, so avoid that. It means you get two questions in one. So do try to ensure that you are logical and progressive and work through it. Okay, I know I've been doing a lot of talking. We've got a lot to cover, but thank you very much for listening. Are there any questions so far? Any comments? It's all examinable. And really what I want you to do is really think very hard about the techniques that you will employ in all of these matters. Okay, well, let's talk about written communication. I suspect that you all know by now that I am very keen on ensuring that the work is professionally presented. Why do I say that? You've got to get your audience's attention from the outset. You need to inspire confidence in the reader. If you are not presenting your material in a professional manner, you are behind the eight ball from the outset. So please do present in a professional manner. And I've got to say that the standard of the work in that regard from this class has been excellent, and I'm really appreciative of that. It'll stand you in good stead. All right. It needs to be well referenced. You are referencing very well collectively. It needs to be logically written, and I think we've talked about that as well. Short sentences, understandable content, write plainly, be concise. This is all examinable stuff. Write in the active, not the passive voice. What do I mean by that? Here's an example. In the tribunal, Jim said the victim lost consciousness. That's good. That's active. Here's passive. The tribunal was told that the victim lost consciousness, or was told by Jim that the victim lost consciousness. Can you see the subtle difference there? It's a bit tricky. You need to practice this. So you need to write in the active rather than passive voice. I'll give you a hint on this. Let's have a look at this. I'll need to share my screen, and I'm showing you a decision which has just been published in QCAT. So it's public arena, so I can do this. How do I share this screen? Sorry. It's been 2 weeks and already I've forgotten how to do things. Here we go. You should be able to see this soon. Can you see a Word document there? QCAT Word document? Okay. Here's a little trick. If you go into spelling and grammar and you do a spell check, at the end of it, if you tick the appropriate box for, can you see this? Readability Statistics. You can see that. You'll see here passive sentences. Oh, I selected a good one, didn't I? There's 0% of passive sentences there. Further down, you've got the flesh reading ease, 47. That's pretty good. The higher the number, the better. And flesh grade level is 11.3. So that's equivalent to grade 11 writing. And that's pretty good. That's okay for written judgment. The way to do that is go into File, Options. Oh, I hope I get this right. Can you see all this? Just give me a nod if you can see it. Yes. So Options, go into Proofing. We'll see if this works. And if you go into, let's have a look. Settings. Yeah, this will provide some things. So you see there the grammar settings and the style settings. That one there is Butte. Make sure you've got that ticked, passive, because if you've got that ticked as you proceed in a sentence, you'll get one of those blue lines saying, no, this is passive, we don't like it. So it's a really good, sensible, practical way of making sure that your documentation is going to be consistent with the way we want things to be done. All right, and here's that Show Readability Statistics. That's the one that brings up those stats at the end of a spell check. Okay, so rather than me talking about what is passive or what is active, if you make those changes in your document, then you can back to the screen now. All right, you can have those things checked as you go. Okay, any questions about that? All right, so thank you. Let's move on then. Oh, now, so question is, so the first person, not the third person? Yeah, that's probably a good way to describe it. I hadn't thought of it that way, but thank you, Letitia, that's good. All right, so change the word settings in Word to assist you. Now, we're talking about your written communication. Plan your thoughts, use headings. Headings can be really valuable. Be professional, not too many words. Avoid capitalizing and underlining headings. We don't do that very much anymore. And use, don't mix fonts. Be consistent throughout the document. Avoid using old-fashioned words and legal jargon like instant. I don't know if you've come across that sort of thing. Avoid the gobbledygook. You know there'll be a question on this in the exam. So in the exam, there'll be a pile of rubbish, really, written by me, and you need to make good sense of it in 75 or 100 words. So have a look at past exams in that regard to get an idea. Has everyone had a look at some of my past exams? It's something that I put on all of mine. If you haven't, it's worth doing and practice a bit. Look at McDonald and Clark Dixon, clear and precise writing skills for lawyers. There's a redrafting exercise, refer to chapter 9. And there is some notes about common documents that you might use. Okay, so I'm sorry it's been such a tough session so far. Are there any questions? Have I still got your attention? Yes. It's not obvious that people are sleeping yet, so that's good. All right. Voice recognition software, I think it's an excellent way to practice your advocacy skills and efficiency. And has anyone volunteered yet to take me on in week 12? No? No one's doing that? No. I've never won yet. I keep laying the challenge and pretending as though I always win, but I've never won yet. So there'll be a typist out there much quicker than me, but it works for me, so I'd recommend it not only for people that have limited typing skills, but for people even with good typing skills. All right, so collaborating. When it comes to collaborating, it can be difficult. Lawyers bluff. Take me on for a typing test, Nick. So there's a Zoom video somewhere in Moodle which says that I'll challenge anyone that wants to take me on in week 12. We'll select a paragraph and we'll just see how fast that can be produced. All right, so collaborating. Look, I think a lot of it is planning, setting some ground rules if you can from the start, cooperating, having a degree of empathy. I think from the outset, if you're involved in a collaboration exercise, just adopt an attitude of aim to give more than you receive. Just think, I'm not going to let anyone else contribute more than I can contribute to this project, and be proud of that. So then, you know, you're not going to be disappointed if in fact you do contribute more. And Jonathan is going to take me on in the typing test. All right, bring it on, Jonathan. That'd be good. Is Jonathan with us tonight? Just give us a wave. No, I can't see Jonathan here. All right. And Griffith University has some policies in relation to collaboration. Okay, I know I've been covering chapter 9. I'm going to wrap it up pretty soon. Kimberly said she'll give it a go. All right, where are you, Kimberly? Give us a little wave. I can't see Kimberly. All right, but that's good. Thank you. So we have a challenger. We're going to have more than one. Mental health and well-being. All right, if you're going to practice in law, you will be under pressure. Prepare for it. This is examinable. Look at the research findings on page 347 of the New Lawyer. Depression affects almost a third of solicitors and 1 in 5 barristers. Perhaps you could take it from that if you're going to practice in law, you should be a barrister, not a solicitor. Is that an appropriate finding? Is that a logical finding from that statistic? But it's very high. It's about 4 times the rate of the rest of the population. If you're going to practice in law, take care with your substances. This is the dad coming out of me now. It really is important. That's why I'm stressing this. Maintain a healthy lifestyle. Please do not succumb to the temptation of simply working and saying, I'm too busy to exercise. I really want to see a plan. If you're serious about practicing law, I want you to understand what you're facing and be prepared for it. I want you to think about strategies that work for you, develop a system that works well for you. I mean, just a simple one we talked about last time was selectively highlighting parts of a text. Tonight we've talked about some strategies, resilience. We've talked about some strategies of developing your own pro forma sheets. That's another strategy. We've talked about having a strategy of putting things in a set place and sticking to a routine. Okay, so these are all things that I can suggest that you need to do, but I would like to see, potentially for the exam, how you're actually going to do it, that was something that works for you. There won't necessarily be a right or wrong answer. We talked about that in law, didn't we, right at the start? One of the advantages of law, there's not necessarily a right or wrong answer, but convince me that what you have in mind is a good way to do things. Strategies, page 356 in your text. Have a look at that. And that might help you. And then in page 360, there is the question of feedback. Now, the feedback won't always be positive. Brace yourself for criticism. Don't argue. You might be criticised by a court. You might be criticised by your client. You might be criticised by your employer. Just be ready for that. Be open to the criticism. Try and keep it calm. Be positive. Take it in your stride. But really importantly, remember the big picture, and that's referred to in that little wagon wheel on page 360. You might think that that's a good way to develop some techniques to avoid the issues of depression and substance abuse that will affect many people who practice in law. Resilience, page 362. Learn to harness the stress and to thrive on it. Adopt a bring it on attitude. I can cope with this. Is that all you've got? That's not a problem. Okay? And you do need to train yourself about this as well. Peter says, a week or so ago, Courier Mail article quoting Rachel Fields about second-year law students being depressed. Yeah, you know, it's serious, and I hope that you've understood that this course is serious, but it's not that serious, is it? You know, we're here to learn, we're here to help people, we're here to help ourselves. So do have fun with it. I'll get cranky if you don't have fun with this course, okay? So enjoy it. You've got an opportunity here. It's not a burden, it's great. All right, so adopt a do it now attitude. That's really important. You know, sometimes you might think, I'm almost up to date. I'm doing pretty well. It's pretty comfortable. Do you know what? On the odd occasion, I can honestly say I've been practicing since 1982, and I have not once ever got up to date. It's always a matter of managing the backlog, managing what's behind me. But occasionally, very occasionally, you get to the stage where you think, I think I'm going pretty well here. I'm pretty much up to date. Immediately that thought creeps into my mind. I say, okay, prove it. Don't tell me you're nearly up to date. By the time you go home today, you be absolutely up to date on everything. And I issue a challenge to myself. All right, see if you can do it. And then suddenly you get the burst of enthusiasm and you try and work as efficiently as you can to get all your work done. You'll never achieve it. So when you think, oh, I'm nearly up to date, I think I'm on top of this, you're probably not. So give yourself those little challenges. And part of the reason you need to do that is you probably don't know what's ahead of you the next day. You might find that you're flooded with work, and that simple task that you thought, well, I got plenty of time, I'm on top of it, I'll do it tomorrow. Well, guess what? You might get swamped for 3 weeks, and that simple task in 3 weeks' time comes back to bite you, and the partner in the law firm says, haven't you done that will? That's really important to do that will. I'm so disappointed. It's such a simple will. Would have taken you half an hour, and you couldn't find half an hour in the last 3 weeks. All right? And you think back to yourself and think, why didn't I just do it that day, right at the start when I could have done it? And then the assignment comes along. Yep. All right, so, and prioritize. And one way that you might do that is having lists or doing something else. Okay, I've talked a lot. Sorry. Are there any questions? I told you there wouldn't be much law per se tonight. This is really practical tonight. but it's really super important. And I'm not kidding, you've really got to think about these things. Okay, any questions? All right, thank you very much for your attendance. You've been very patient. 6 years of admin experience really comes in handy, yep. Okay, all right, well, I'll stop recording. Thank you.